Judge, ask Ms. Ann to go ahead and mark the next exhibits. Sure. 106 will be the autopsy, and there's the X-ray picture and a picture of the bullet from the body. Those are the picture of the bullet is in a bag.
Did you say 106?
106 will be the autopsy, and 107 and 108 are pictures. And Judge, if it's agreeable with everybody, there's a diagram. The diagram that the court references in the autopsy.
Yeah, we
got to put that on a slide, but I was not going to make that a separate exhibit since it's part of the autopsy and that's acceptable.
Okay, that's fine. Unless there's objection to it. Very good. And if they want to stipulate to the cause of death, does that change anything or doesn't change anything?
State's going to put on Dr. Deere if they want to. They cross-examine or not cross-examine, but I think the jury needs to hear from Dr. Deere.
Okay. All right. All right, somebody rise, please. You're bringing the jury back in. And I'm going to swear you in. Thank you. Have a seat. The record reflect our jurors have returned. Sir, if you'll raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you. If you have a seat, if you'll tell me both your first name and last name and spell them both.
Good morning, ladies and gentlemen. I'm Dr. Thomas Deering, Thomas. Last name is D as in dog, Eering.
Thank you. Questions?
Just preliminarily, we introduced this picture yesterday in a copy. My hand marked that as a student. Yes.
So that's our work opposite for students.
Yes.
And Dr. Deering, where are you currently employed?
I'm employed by a company in Nashville. It's Forensic Medical Management Services, and we contract to be the medical examiners for Metro Nashville. We're also a group of forensic pathologists. There's 8 of us now, and we offer autopsy services to any of the medical examiners from any of the counties in Tennessee. And there's a large group, mostly from Central Tennessee, that when they have a case that needs an autopsy, will send to us.
And Dr. Deering, is one of those counties that your group performs autopsies for, Marion County?
Yes, it is.
And Dr. Deering, what is your educational background?
Well, I'm an MD, so I got through medical school. I have a license to practice medicine in Tennessee, an active one in Tennessee. I did an internal medicine internship, a 1-year internship up in Michigan. And I got through school on the Navy, so at that point the Navy called me to active duty, and I was assigned as a general medical officer to the Marine Corps down in Albany, Georgia, and finished my payback there. I went back to school, and I did a pathology residency in Milwaukee, Wisconsin. And then the last formal year of training was a fellowship that I did in forensic pathology, and that was in Memphis, Tennessee.
And Dr. Deering, are you a board certified in any area?
Yes, I'm board certified in anatomic pathology, clinical pathology, and forensic pathology.
And Dr. Deering, have you testified from time to time in the courts in Tennessee, and I know you've been to the 12th Judicial District as an expert witness in this field?
Yes, I have.
And we would tender him as an expert in that area?
Dr. Board, I have this issue. No, sir. All right, I'll let you give us a picture.
And Dr. Deering, can you describe the first phase of performing an autopsy on an individual?
Well, in this case, we call these out-of-county cases. The body is sent to us in a body bag, and we'll open up the body bag and we'll take a picture of what we get, clothed, unclothed, wrapped in a blanket, whatever the condition of the body might be. And we'll take that out and we start our examination. We make diagrams. We look for valuables and we put them in a safe. We look at what clothing is there and we document that so we can give it back to the family if it's still good stuff. When we take the clothes off the body, we'll look for injury, we'll look for signs of illness. We might take an x-ray in a certain kind of case. We certainly take photographs and we'll complete our diagrams. And that kind of at that point, that's our initial first step. When we're done with that, and I'm satisfied if I'm the pathologist doing it, we open up the body. So we have a way that we can open up the torso, the main portion of the body, and even the head, and we can see all the organs where they sit, including the brain. We can look for injuries at that point. We can take the organs out and weigh them. We can dissect them. We look for injuries. We look for illness. We collect specimens like blood for toxicology, looking for drugs. We can take urine, the kind of specimens that you've heard of before. We collect evidence sometimes, like we might get bullets that we find in the body. And what I'm looking for is to answer two questions. I answer, what's the cause of death? And there's a lot of choices for that. Could be natural disease, could be some kind of trauma. And we identify based on what we find, what we think is the cause of death. And then, mostly based on the circumstances, we make a second decision of what the manner of death is. And you've heard of those. Our choices are homicide, suicide, accident, natural, and undetermined, or we can't be sure, based on it. And that primarily depends on circumstances, and it's a little more of a statistical tool, or it's a medical opinion.
As to the cause of death.
Correct, how the cause of death came about.
And Dr. Deering, did you perform an autopsy on the body of a Jerry Don Ridge in May of 2016?
Yes, I did.
And Dr. Deering, how did the body present at the medical examiner's office in Nashville?
Well, what was striking initially about this is that this body is burnt. It was nearly completely burnt, and a lot of it was charred. There was a little bit of sparing across the back and kind of down the center of the back, but the rest of it was burned, and there were changes to the body that happen when a body is fairly severely charred, and this one showed those.
And what type of changes would occur to the body when it's severely charred?
Well, all the hair, the upper layer of skin can be burned away. Bone can be exposed. If there's areas of injuries and then the body is burned, those bone ends sometimes get exposed much earlier than they would if they weren't injured, and you can see burning of the bone. There are a number of changes that happen when a body is burned. The hands and the arms curl up, kind of like someone who's going to box. You can see that with the feet, and the legs can curl up. But in general, the usual things that you use to identify people are gone. So I can't see tattoos, and there's really no hair that's left. The skull gets exposed, things like that.
Dr. Deering, we have a photograph from the scene, if you bring up Exhibit 5, which depicts the body at the crime scene, and is this consistent with how the body appeared when it arrived at the ear facility? And the body is towards exhibit number 7, and is that...
Yeah, now when I get it, of course, it's been removed from put in a body bag. The yellow you're seeing, that's the subcutaneous fat, the stuff underneath the skin that you see. The skin's been burned away. So, yeah, I mean, that's consistent with the body that we received.
Is that what you refer as charring injuries?
Yeah, charring is even more than a third-degree burn. The skin is blackened, or it's been so burnt that it's gone.
And Dr. Deering, did you also, as part of, you examined the body initially, from your initial just observing of the body, were you able to ascertain any wounds just from your visible inspection of the body?
Well, I did. There was a couple areas. The right arm was unusual. There were ends of a bone fracture. The right upper arm was fractured. It was sticking through the charred skin, and that's unusual to see just from burning alone. So that was an area of interest. And the second is, initially I called it an unusual skin split that was here. Now, the skin is charred, it's blackened, and there's a split, and skin does split. So I have to do further examination, but just from an external exam, I was interested in this left side of the neck, that there might be an injury there.
Dr. Deering, let me show you what we've marked as Exhibit 107, and are you familiar with that?
Now, this is a copy of one of the x-rays that was taken in this autopsy.
And we would move that into evidence at this time. Yeah, you can bring up the x-ray.
So we've not had the x-ray introduced before?
I don't know, we have not.
So we'll make that the next number exhibit. What number will that be?
107. No, 106 will be the autopsy. I'm a little bit out of order, but
Okay.
I'll tie it together. And Dr. Deering, looking at the upper of the right arm, you have a pointer, Chad?
Is that there?
I have it.
Okay, yes, if you can point out what you're referring to on the right arm.
Well, this is a post-mortem x-ray. We have a machine that enables me to take an x-ray from head to toe in one picture, so I get a good idea of everything overall. And this is the right upper arm, and I mentioned I could see the ends of the bones. These actually stuck out, and this is a fractured right upper arm bone, the humerus, and this is a metal object in there that I recovered during the autopsy, and it's a bullet. It's a bullet that's been smushed at the front. It's hit a hard object, and certainly the bone could do that, and it deformed the bullet. In going back, if you'll pull back just a little bit, I just want to talk about this right here. Here's another bullet, and this bullet was under the body. It actually wasn't a bullet that was inside there. Whatever the body bag or the sheet that the body came in, there was just a loose bullet that was present, and it stuck itself to his skin. So we recovered that bullet too, but it's not actually inside the decedent.
That had nothing to do with his death.
It had nothing to do with his death.
And how would you describe the gunshot wound to the right arm in terms of the damage it would have done to the body of Jerry Ridge?
Well, it completely breaks the bone. It's the fancy medical term is comminuted. There's multiple pieces, so it hit it square and did a significant amount of damage to it. That gets even magnified because now it's open to being burned, and as the skin is burned there, it can get down to the bone, and it burned the ends of the bone that were sticking out. But this is a very significant fracture, and certainly the vessels, the arteries and veins that run along this could well have been severed with this shot. In other words, it could bleed.
And also, Dr. Deering, there was another wound to the body, is that right? And where was that located?
There isn't. May I mention, so we're here and we're seeing it? Am I allowed to, just so in case you wondered what this is about?
Yeah, go ahead.
These are not injuries. These are little wire loops from a gentleman who's had coronary artery bypass grafting. And they replace the sternum and they tie it together with metal wire. And that's what these are. So these are not injuries. This is not debris from the fire. This is a gentleman who has had heart surgery before. And the second area of injury, there's not much you can see here, but it's going to be in the left neck, and there's really nothing I don't think you can see on x-ray.
Dr. Deering, let me show you what's been previously marked as Exhibit 108. Can you identify that?
Yeah, this is a copy of the picture we took of the bullet. We're kind of looking at it head on, and this is the bullet recovered from the right arm.
Okay. Take that in this Exhibit 108. Yes. And Chad, you brought it up. And we're now looking at Exhibit 108 on the screen, and Dr. Deering, I notice it has the MEC number. Is that the medical examiner's case number?
Yes, that's the number that's been associated with Jerry Ridge.
And that bullet would have been maintained by your office and then released to law enforcement?
That's correct. Yes, we maintain it as evidence and sign it out.
Dr. Deering, let me show you a copy of the autopsy, and I'll ask, is that a true copy of the autopsy?
Now, this has several things, typical things here. The cover page is the report of the medical examiner's office.
Let me slow you down just a second. But is that a copy of your autopsy?
Well, I'm answering your question. This is a copy of this. There's several things here. There's the report of the office of the medical examiner is the front page. There's a copy of my autopsy, including my diagram that I made myself, and there is a copy of the toxicology report. So that's all included in this particular packet.
And we would make that Exhibit 106, and that's been marked on it. Okay. Sorry to interrupt you, Dr. Deering. I got ahead of myself. And Dr. Deering, if you would turn to, first of all, the laboratory report at the end of the autopsy, that looks for various drugs and alcohol. Is that right?
That's correct.
And Mr. Ridge was negative for drugs or alcohol.
Yeah, this particular test focuses on particularly drugs abuse and common drugs, as well as drinking alcohol. And it was negative or none detected for all those on the screens.
And doctor, as far as with a death in a fire scene, would you also check for soot in the lungs or the trachea, as well as the presence of carbon monoxide in the blood?
Yes, we do that routinely.
And did the body of Mr. Ridge have any soot in the trachea or esophagus?
No, I look for that. I open up the airway, are the words he's using. So from the top of the airway down to where it breaks into the lungs. And I didn't see any soot. And soot is just soot. It's just black or gray material. So to double check that, we do a blood test for carbon monoxide. And his carbon monoxide was none detected.
So as far as whether you concluded he was deceased when the thermal injuries occurred, is that correct?
Right. Another way to phrase it, I think he was dead before he was burned.
Okay. And Dr. Deering, if you would turn to the diagram that you created, I believe on page 7 of the autopsy.
Okay.
And we can bring that up on the screen. And Dr. Deering, if you would describe what we're looking at and this is from Exhibit 106, page 7.
This is just kind of our common body diagram. This is me, and I'm sorry about the writing. I'll do my best here. For the little hash marks that I put, I'm just demonstrating what areas are burned. And I mentioned on the back, I put small spared areas, and they're actually larger than drawn. It's almost a T-shaped kind of an area that was spared. Suggests to me the body was perhaps laying on its back when it was burned, and that was protected longer from the fire. The very top one says a round defect in the soft tissue, and then I put no hole in the skull palpated. So I'm going to show you that. That's this one here. Concerned that it might have been a gunshot wound, and it didn't really turn out to be anything that I could prove. There's no hole in the skull underneath it. Then here I put blood extrudes. So this little slit, as I'm first looking at it, blood's coming out of it, which is a little unusual for just a skin slit in someone who's been burned. And so I put split question mark in the skin. The edges are burned, and then I came back later and I wrote KSW, knife stab wound, 1 1/4 inches long. And that was my opinion that this is a knife stab wound to kind of that left lower neck area.
Did the knife stab wound sever a vein or an artery?
Well, and how I decided that it was a knife stab wound is I lift up the skin and we go into the neck routinely. And when I got in there, I looked carefully for injuries, and a left internal jugular vein was cut. And I didn't cut it. And there was a lot of blood in the soft tissue around there. The other structures like the airway and the carotid artery were intact. But this is a stab wound that injured a major vein in the left side of the neck.
And the vein, will an artery spurt blood?
Yes, an artery will spurt blood. A vein, it's a fairly large one. It will just continue to bleed at a kind of modest level.
Okay. And go ahead, Dr. Deering, with describing page 7, the diagram.
FX, fractured humerus. That's the arm bone, the upper arm bone, with sharp ends extruding and burned. And I mentioned that before.
Okay.
Mentioned the spare parts. I just say the fingers are curled. I made note in the autopsy that I didn't see some of the position, that boxer position I told you about as much. And that may be because I think because the arm was injured before it was burned, so it didn't have that same burn effect. I put that the right leg is flexed at the knee. Down by the foot it says there's a remnant of a burned sock. His genitalia are burned. And here I put that the bone is exposed. That's a common burning phenomena. There's not much skin above the shin bones, and so it gets exposed fairly early. And then this is just my key. This little hash mark is just 3rd degree and charring burns. And I have some, black and red, some of the color that I'm seeing. And I think that's everything that I annotate on the diagram.
Dr. Deering, based on your examination of the body, did you reach an opinion as to the cause of death for Mr. Ridge?
Yes, the cause of death, in my opinion, is the knife stab wound to the neck. And I contributed to that cause of death, a gunshot wound to the right arm, because that could certainly have a significant amount of hemorrhage. And that's my cause of death statement.
And also, Dr. Deering, as part of the autopsy, do you obtain a blood spot that can be given to law enforcement?
Yes, we draw toxicology and we do a blood spot as generally for DNA.
And was that done in this case?
I believe it was, yes.
And that would have been released to law enforcement?
Yes, if they requested, yes.
Just one moment. That would be all my questions for Dr. Deering.
All right. We have no questions, sir.
Thanks, sir. Instead of that, we appreciate it. Have a good day.
Thanks for your time.
Appreciate it with us.
All right, I believe state will rest.
All right, thank you. I'll let the doctor let you step up. Move on.
Important stuff.
When the state is arrested, that means they put on all their proof. I've got some things I need to talk to the attorneys about, and so I'll probably need, I know we're to write this morning, so I apologize if I can take another one, but I've got some things I've got to do with the attorneys to help us keep this statement. So we'll take another 20-minute break, and so if y'all will go there and make yourself comfortable, and I'll try to keep it at 20. I'll do my very best to bring it back in 20 minutes. All right? So there's our live, please. To amend the indictment on, get it out to you, especially if you made robbery, all the other felony work.
It was on felony murder, and then the mens rea, one of the other charges regarding substitute for instead of ban. We're still of the opinion that it put our client to trial on charges that were not returned by the grand jury, and as such, if you look at the original wording of the indictment, that the proof was insufficient for those 2 counts, so we are definitely asking for judgment of acquittal on those 2.
And what's the state's position on that?
County state feels there's enough on both those matters to go to the jury.
I'm expecting just a rule on this motion that the state's case is best light, and so I'm going to deny those motions this time. Do y'all have a copy of the jury charge? Most on the computer.
Your Honor,
We printed it off this morning. You're on that bill. So let's open that up and go through that. And we'll start out with the work where the word starts out and we'll do the dark print. Public here together in our spot. As we go through this, stop anytime. Okay? Please. On page 1, I just go through and announce what the indictments are on counts 1, 2, and 3. Any objection to page 1? On page 2, I list counts 5 and 6, and then I also tell them they're the exclusive judge of the facts, and I also define direct and circumstantial evidence. That's on page 2. And what we'll do is I'm just going to go through this, and y'all stand up and make any kind of point you want to if we get to one of these. Sure. Page 3 finishes up on circumstantial direct evidence. At the bottom of that page, it talks about how someone may be impeached. Page 4 also talks about how people can be impeached. Page 6 is count 1, first degree murder, premeditated killing. And I go through and set out what the elements are of that, and then I describe the mental state that we use to go through that as well. On the next page page, I continued that, and I put in there that if they find the defendant not guilty of that, it is considered the lesser included offense of second-degree murder. On the next page, I talk about second-degree murder. I say that it's a lesser included offense of counts 1 and 2. I set out the elements of second-degree murder. I also set out the definition of knowingly and intentionally. And then I say that if you find them not guilty of second-degree murder, then you consider the lesser included offense, I think, of voluntary manslaughter. And I also, on that next page, talk about the difference between voluntary manslaughter and second-degree murder. The next page is a lesser included offense of count 1 and 2, and that's homicide, voluntary manslaughter. I set out the elements of voluntary manslaughter as well. And then on the next page, I tell them if they find not guilty of that, they're considered the lesser included offense of reckless homicide. On the next page, I define reckless homicide. I say that that's a lesser included offense of counts 1 and 2. I set out the elements of lesser included reckless homicide, define the term recklessly, and then on the next page, I tell them if they find, then they can find the defendant guilty or not guilty of that. And then if they find not guilty of that, then they consider the next lesser included, and that's criminally negligent homicide. I set out the elements of criminal negligent homicide, define that. And then on the next page, I say they've gone through an additional charge, and then on the lesser included, it's still found not guilty, then they find the defendant not guilty on that charge. The next count is count 2, which is first-degree felony murder. I put out there the elements of felony murder, noting the objection that was previously made by the defense. In there, I had robbery. I set out, I tell them that later on in these instructions, the definition of robbery is defined. And then I talk about the intent to commit an underlying felony. That's got to exist, and that's how you find felony murder. Then on the next page, I kind of briefly go through those lesser included offenses that I already went through in regard to premeditated murder. I do that on the next 2 pages, I believe. The next 3 pages. And that ends as they go through those lesser included offenses. If they go through all those and don't apply any of those or find that they're applicable, then they're found the defendant not guilty. The next count is count 3, which is especially aggravated robbery. I set out the elements of especially aggravated robbery there, and then for the next 2 or 3 pages after that, I give definitions in regard to especially aggravated robbery. And then after that, then I tell them if they find or not guilty of aggravated robbery, then they're to go to lesser included offenses. And the first lesser included offense is especially aggravated robbery is aggravated robbery. I set out those elements as well, and then set out the definitions that are already defined. And then I say there that if you find them not guilty of aggravated robbery, you can consider the lesser included offense of robbery. Then I have the lesser included offense of robbery. I set out the various elements on that. I say that there's some words I've already defined that later on, better word defined earlier to this. And then I put in there that if you find them not guilty of robbery, then you should come back and consider all the initial charges of lesser included offense. Then you're to come back with a not guilty verdict. Count 5 is aggravated arson. I set out the elements of aggravated arson, have the definitions again that I previously used. I put in there that if they find they're not guilty of aggravated arson, they're considered the lesser included offense, which is arson. And so arson is the lesser included offense in count 5. I have all the elements set out in regard to arson. I have the definitions again of arson. And then I say they find not guilty of that, they consider the lesser included offense of reckless burning. And reckless burning, I set out those elements as well. I define recklessly again. And then I put if they've gone through the initial charge and those lesser included and found they're not guilty of those, or found those are not applicable, then they're defined or not guilty. In count 6 of theft of property, I set out the definition. The elements for theft of property set out those same definitions I mentioned before. Then I can tell them they find or not guilty if they choose to do that. And then I also have where they fix the value, and that's on the verdict form as well. They look at the fair market value of the property, time, and place of the offense, and the fair market value not be estimated cost for placing the property within a reasonable time. Then I added the stated requested concealment charge. I've determined that that's appropriate to add. I've added that concealment charge in there that says that you try to destroy property. And I just,
I know the state submitted one,
but it starts out as any attempt by a person to destroy evidence in a circumstance which, when concealed with all the facts in the case, may justify an inference of guilt. While that inference is by no means strong enough in itself for conviction, it may become one of a series of circumstances in which guilt may be logically inferred, and so on from that.
It's not in our copy, but we printed some of it. The next page we have is, I guess,
Ours jumps from valuation to expert witnesses.
Okay.
Or fixing value to expert witnesses.
All right, let me go back to it.
I have 2 copies I can give.
Okay.
I'll give ours.
So your second, our copy does have your.
Yes.
Yes, ours has it.
To be honest with you, counsel, that's probably my fault. I sent y'all so many of these things, so I accept responsibility for it there.
okay.
And that's from the intensive pattern instruction, so it's exactly the one that y'all sent me. I did not give that addition to the rules. And you're exactly right, after that one is the expert witness.
I guess we may have, I think, penalty value.
We do.
Not have it.
It just doesn't have a heading at the top, so we didn't have it. It's just that right. So it was part of the other.
Y'all go ahead and put on the record that you object to be charging that.
Yes, Your Honor.
And I'm going to overrule that objection, I decide that I'm going to charge that. Then the next one just says, I rule upon certain disability of evidence, and you're not supposed to concern yourself with my rulings, and then it also says that what y'all say is not evidence, but it's to help them understand. And then we go to the next page, which is expert witnesses. Y'all look at that carefully to make sure I've got everybody listening. I think I did. If I don't, or have too many people, it's about one of those. In there, that instruction, just a pattern instruction, it says just because they're an expert witness, that doesn't mean you're bound to accept their opinion. And it refers back and says you're to treat them with the same credibility questions that you would other witnesses as well. The next page depends on whether or not the defendant testifies or not. I've got 2 in there. One says if she does testify, her credibility is determined the same as with anyone else. And the second one says if she doesn't testify, that they cannot use that against her. To be honest, I've given that charge twice, but I've given it one more time. Make sure the jury understands that she cannot be punished if she chooses not to testify. And then the next one says they will not be responsible for setting the sentence here. The verdict's got to be unanimous. They've got to consult with each other, no prejudice or sympathy. And then I have the identity charge, basically. And that just says that the state is responsible to prove the identity, that this is in fact the person who in fact committed this killing. I also tell them on the next page that it becomes necessary for them to communicate with me. They can send a note to me for us to meet and try to answer a question. But I try to make that clear that I really can't answer a whole lot of questions. I also tell them that they've taken notes during the trial. They can use that to refresh their own memory, but they cannot use it to convince other jurors. Like they cannot read their notes with their other jurors. Then I go through again and tell them they've got to select a 4-person. I tell them they're to consider each count of the indictment. I also tell them they're to consider each lesser included offense. I mentioned again reasonable doubt on that. I tell them on the last page, you shall not proceed any lesser included offenses until you first make it unanimous. determination that the defendant is not guilty of that immediately preceding greater offense. And then I just say that the crimes charged in each count of indictment is a separately distinct offense, and they've got to decide each charge separately. And I hope you also have a copy of the verdict form. Y'all have that? It's the same one. I've not changed it. I can show you right up here. It's the same one I've sent y'all. I've not changed it since the first time. It's the same verdict form up here. Count one is first degree murder, and then it's got all the lesser included down there. And the last one down here after the going to the lesser included says we find the defendant not guilty.
Could we have first?
Sure. All right, so I've got, yeah, that's the other one. Okay. So, if you don't mind, go ahead and 2 more copies. Let me just get you copies of the ones I'm going to use. Those are my first ones, and I was already satisfied how that looked. I thought it was too confusing, so I'll give you these new ones. Counsel, while she's making copies of that, here's my waiver form where she's going to check one way or the other whether she's going to testify or not. We're going to review that. Obviously, we're going to put her on the stand. She's got time to do one way or the other.
We were just wondering if we could, obviously we've discussed this in the past and some today, but we just have a short consultation whether to decide on finally.
I'll appreciate that. I'll do that.
I heard you wanted to read the charge before argument, is that correct?
Okay. I found in my experience that's useful to y'all because that lets you use the charge instead of anticipating what I'll charge. But I guess it's my discretion. So. Before we're making that copy, you may have noticed I took out something that you asked me to put in. That was the one where if there's several incidents of violence, that kind of count multiplying towards the end. The reason I took that out, the reason I'm not going to charge that is I did some research on that. The other cases I found where that was used was in domestic violence. And I had a case just like that where the boyfriend and being constantly throughout their relationship. And so I really couldn't find that to be used in a situation like this. So I might be wrong. I'm not the first.
No, that's my mistake, Judge. I think you're right on that.
So counsel, here's my new improved voting form. I want to make sure that these lesser included offenses were clear, that I want them to be able to consider that. So if you look at count one, that's first degree murder, and I start out with first degree premeditated murder, and then I go through all the lesser included, and at the very end, we the jury find the defendant not guilty, and then the presiding juror will sign that and date that. The next verdict form is in regard to felony murder. Once again, I have all the lesser included again, and at the very end, not guilty, we have to let the guy unanimously we found. Those are not applicable, and that's for the juror, presiding juror signs well. Next is especially aggravated robbery. I have the lesser included offenses there, aggravated robbery and robbery, then find the defendant not guilty. That's signed and dated as well. Next count 5 is aggravated arson. I have aggravated arson, the lesser included offenses for arson and reckless burning, and then not guilty, and then presiding juror found there, and then finally theft of property, and that's where they put a value, or they find the jury not, or they find the defendant not guilty in regard to failure to establish a value. Okay, the state, do I have any suggestions for addition to my list?
No, Your Honor.
minutes. That'll be your previous objection to that. Okay. But is there anything else?
Not at this time, Judge.
Okay. And so tell me how long, a couple of questions. How long do you need to speak to your witnesses? 10, or your clients 10 minutes at a time? I think so to do that. And then after that, can you tell me, let's say that she decides not to testify. Can you tell me how many of the witnesses you anticipate to call back on that, how long the defense will last?
Judge, if we recall, there were two other witnesses I anticipated to be short.
Okay. All right. So I'll step down for 10 minutes. I'll come back, let y'all tell me which way you want to go. We'll still have to put her on the stand.
Sure.
And go through this. I'm sure you've done it.
We have.
1,000 times, so we'll do that. And then I'll bring the jury back in, and I'll let you start putting on your defense. Is that satisfactory?
One moment. That's fine, Judge.
Okay. And then once we get done, if you're approved, and on what time it is, I may go ahead and just instruct the jury right then, if y'all have any serve on the proof that you put on, and then probably break for lunch, and then come back with closed arguments, and then try to get to the jury. Is that reasonable?
Yeah, it sounds like a good plan. That sounds good, yes, Your Honor.
Okay.
It's good to say.
Okay, so if you tell the jury we got 15 more minutes, and I'll see y'all back in here exactly 10 more minutes. Okay? All right. Thank you. May I please step up here next to me, please? You'll raise your right hand.
Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you. Have a seat. If you can tell me both your first name and last name and spell them both.
Angela, Angela, Kilgore, Kilgore.
Thank you. And do you need this script or you think you got it? She'll get back in and try to do that.
Not what I thought, but that's fine. Did you swear?
I did.
Okay. Ms. Kilgore, I'm Norman Lipton, and I'm your attorney, and been your attorney for a couple of years now, correct?
Yes, sir.
Okay. And we're here, we discussed this many times about your right to testify, correct?
Yes, sir.
And we've discussed the pros and cons of testifying many times,
Yes, sir.
okay? Alone to decide to testify or not to testify,
Yes, sir.
okay? And again, not only have you discussed it with me, but other attorneys have been present from my office or from our office with regard to whether you should testify or not.
Yes, sir.
And, you know, the judges has instructed in the past and will instruct in shortly that, you know, they can't draw any inferences. They will be told that they can't draw any inferences from you not testifying.
Yes,
Right?
sir.
Okay. And we've answered all your questions, I think, about pros and cons of testifying, correct?
Yes, sir.
All right. And with all that, we've shown you a waiver form that the judge has given us, and you've read that.
Yes, sir.
Okay. And I guess, Judge Manapro?
Sure. That's your identify. Perfect.
Can you just take a look at this? And this is a document that you have looked at and signed?
Yes, sir.
Okay. And this document is entitled waiver, and it basically says, after considering my rights and asking any questions I have regarding those rights, I choose to, and you have chosen to waive your right to testify.
Yes, sir.
And that's a fancy way of saying you don't want to testify even though you know you can.
Yes, sir.
And that's your signature, right?
Yes, sir.
There. My signature below yours.
Yes, sir.
You've
If you
seen my
call-
signature before. It's my signature, Judge. And this is today's date, and that's an X with a waive my right to testify.
Yes, sir.
And take a look at that, and we're going to ask you to initial the line next to it. After you've read it again, decide not to testify.
Wearing my glasses up here.
And that, right next to the X is saying, I waive my right to testify.
I'll have that, make that part of the record. Thank you. You step down now. I'll take my sheet of paper back.
I'm sorry, go ahead.
That's very much.
Actually, ma'am, look at this one more question, for sure. Ma'am, you're not under the influence of any drugs or alcohol or anything like that,
No, sir.
All right, so stay ready to bring the jury back in?
Yes, Your Honor.
Counsel, you ready to bring the jury back in? Yes, sir. Okay, everybody rise, please. Thank you, have a seat. Ladies and gentlemen, I appreciate your patience. I know you were back for longer than 20 minutes, but I got a lot done. And I think you'll be pleased, and the lawyers did a great job helping me, so thank you for your patience in that. All right, and who'll be your first witness, sir?
yes, recall Mark Wilson.
Mark Wilson. Okay. Mr. Wilson, please step back up here. You're still under oath, sir. Yes, sir. Mr. Wilson, could you spell your first and last name and spell?
Kenneth Wilson, Kenneth Wilson.
Okay. What?
Mr. Wilson, I think you previously testified that you were part of a bunch of law enforcement officers who went into Miss Kilgore's garage, correct?
Yes, sir.
Okay. And as part of that, you saw 5 saddles, I believe?
I believe it was 4 or 5. I can't, I'm
You saw
not
some
exactly sure.
saddles?
Yes, some saddles.
That was not taken into evidence, correct?
That's correct.
Okay. And let me show you a photograph. May I approach you?
Sure.
You recognize that photograph?
Yes, sir.
And what is that photograph?
It's a box of, looks like some latex gloves and also some swabs or syringes.
Okay. And where was, that photograph was taken at her garage, correct?
That's correct.
As
Yes.
part of the search warrant, as part of the search that law enforcement did?
Yes, sir.
Okay. And you saw that box there on that evening?
Yes, I did.
And could I ask that it be marked and put up on the screen, if you would? And that's the photograph there, correct? On the same photograph on paper that's up on the screen?
Yes, sir, it is.
And this is the- And can you tell me what color those gloves are?
The blue,
Not purple, correct?
that is correct.
I have no further questions. And Judge, if we haven't marked it on the record, I think that's 109.
Thank you, sir. 109. Any cross-examination? No, Your Honor. Thank you, sir. You sit down.
Thank you.
Who's next?
Judge, we'd ask that you step out and call Mr. Dwight Inglis.
White, please.
And, go to the officer here. Actually,
Show yourself appearance today, please. To raise your right hand.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. If you have a seat right there. And if you'll tell me your first name and last name and spell them both.
Ron Inglis, RONALD INGLIS.
Thank you, sir. Questions?
Mr. Inglis, you were driving by the pawn shop that day on May 17th, correct?
Yes, sir.
And can you tell us what you saw?
I saw a red pickup backed up to the door. The door was closed, and that's all.
And what time was this?
Approximately 4:45 Central Standard Time.
Okay, and how do you know that? How do you know it was 4:45?
We had left Jasper here at 4:30 and drove up the valley. It takes approximately 15 minutes to get there.
Okay, and you consider yourself something of an aficionado or an expert on trucks, is that right?
I know a little bit about them, not a whole lot.
Okay, well, we discussed outside that you were a Chevy man, but you had 3 Chevys and 1 Ford, something like that?
Something.
And can you tell us, do you have an idea as to what type of year that car was, that truck was?
Approximately an older model, say 05, somewhere in that area, with the rounded front end on it, with a large size pickup.
And when you saw that and you heard about the fire, you went to the sheriff's department pretty quickly thereafter.
I talked to the sheriff, I guess it was 3 or 4 days later when I ran into him.
Okay, and you told him what you saw?
Yes.
And let me show you the photograph. That first, Judge?
Sure. And it says something like organized exhibits.
Yes.
Yes, you know, it's 83, 83 number. I believe it's 83.
93. Okay. Similar to that, but an older model, correct?
Right.
Okay. And how do you know it's an older, and if you can put up 93? And what makes you think it was an older model? And can you tell us what about that truck makes you think it was an older model than the one depicted there?
I would say it was an older design than that.
It was an older design than that, and again, I'm not a truck person, so if you could tell us what the older design would be.
The headlights are a little more rounded to the center of the hood, but come from around the side like that also.
Okay. Anything else?
Not that I can think of.
Okay. I have no further questions.
Cross-examination. Mr. Inglis, that day you'd been in Jasper, is that right?
Yes, sir.
And were you with your wife?
My wife and my mother-in-law both.
Bless you. And y'all had been to, you remember talking to Mark Wilson at TVI. I believe he came up to your house and your dog wanted to chase the ball. What's your dog's name? Is that Henry?
Yes.
Henry the dog. And you told Agent Wilson you'd been at the co-op. Would that be here in Jasper?
Yes, sir.
And that would have been about 10 after 4.
Right.
And then you went to the Fred's. Was that the Fred's here in Jasper?
Yes, sir.
Okay. And that would be like you're going towards Kimball. Is it that Fred's?
Yes, sir.
And did you go any Fred's or just let the ladies go?
My wife ran in and got a phone card.
Okay. And were you driving?
Yes, sir.
Okay. And then you stopped at the BP here in Jasper and got gas?
Yes, sir.
Okay. And then you headed up the valley?
Yes, sir.
So you were going through Whitwell, 20 to 5, quarter till, somewhere in that time frame.
Yes, sir.
And what's the speed limit there through Whitwell?
40,
40, 45?
40, 45, 40 through the school section, and I think it goes back to 45 after you go past the red light.
Okay. And where the pawn shop is located, there's no red light or stop sign around there.
No, sir.
And you're on the main road?
Yes, sir.
Highway 28.
Yes, sir.
And so you're driving by, and I'm assuming, Mr. English, you just glanced over at the pawn shop,
Yes, sir.
and you noticed a red truck.
Mhm.
And then you went on about your business.
Yes, sir.
And when you heard about the fire, did you hear that they had some interest in a red truck?
Not really.
Okay, you just called the sheriff and told them what you knew?
Yeah, that I saw the red truck at about that time.
Okay, thank you, Mr. English.
Can you read it right? No, sir. Okay, thanks, sir. You said that, you said call before you go.
All right, thank you.
Thank you.
Judge, we have one more witness, Randy Mosier.
Okay. Randy Mosier. Sir, if you raise your right hand for me, please. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Thank you. If you have a seat, please. If you'll tell me your first name and last name, and spell them both.
Randy Mosier, R-A-N-D-Y-M-O-S-I-E-R.
Mr. Mosier, would it be fair to say that you don't want to be here?
Yes.
Okay. And Mr. Mosier, you know Jerry Ridge, or knew Jerry Ridge, correct?
Yes.
And you went to school with Angela Kilgore.
Yes.
And on May 17th, the day this incident happened, you were in the pawn shop talking to Mr. Ridge when Angela Kilgore came in, correct?
Yes, sir.
And what time did you get to the store?
It's about 1:15 when I got there.
You recall what time you left?
1:45.
1:45 to 2, does that refresh your recollection? As to
Sir.
Maybe 1:45 to 2, you weren't sure exactly how long you were there?
I was there about 30 minutes.
Okay. And you were talking to Mr. Ridge or Jerry, correct?
Yes, sir.
And you were there, just you and Mr. Ridge, correct?
Yes, sir.
And everything seemed fine?
Yes, sir.
You were having a normal conversation with him?
Yes, sir.
And then you saw Angie Kilgore?
Yes, sir.
What happened next?
We just seen a red truck pull in and back up to the front door. And Angie come in, and I asked her why she had a pair of gloves on. And she said she had poison oak on her hands.
And what color were the gloves?
And the ones I seen was blue.
Okay. And anxious or unusual, or
No, sir.
everybody seemed fine?
Yes, sir.
You see what kind of shoes she was wearing?
No, didn't really pay any attention. I know, sir.
Did you tell the sheriff's department that you think they were sneakers or tennis shoes?
I might have, I don't remember.
That's it, Judge.
Cross-examination.
Mr. Mosier, you and Jerry were friends, is that right?
Yes, sir.
And Mr. Mosier, you would stop by from time to time just to visit with Jerry?
Yes, sir.
Just talk about whatever,
Yes, sir.
maybe look for a bargain in the pawn shop? Okay. And on May the 17th, when this fire occurred, you just stopped by to visit in the mid-afternoon, 1:30, 2 o'clock? And then Miss Kilgore pulled up, and did you recognize her truck?
No, just when she walked in, I knew who she was.
You knew who she was, and it was a red truck she was driving.
Red truck, yes,
And it was backed up to the front door there of the pawn shop.
yes, sir.
And you stayed a few minutes, and then you went on about your business.
Yes, sir.
And Miss Kilgore was there.
Yes, sir.
And the only unusual thing about you remember about Ms. Kilgore is she was wearing those latex-type gloves like doctors would wear,
Yes, sir.
and she said it was poison oak.
Yes, sir.
Okay, thank you, Mr. Moser.
No, sir. Thanks, sir. You step down. Please stand for free throw. Defense rep, Judge. All right. You would well appreciate all that.
Just one moment, I'm sure. No, sir. No rebuttal from the state.
Okay. So, ladies and gentlemen, that means they can prove the evidence in this case. So that means you can quit taking notes. You don't have to take any more notes.